On June 29th, the Supreme Court handed down a ruling that quietly rewrote a rule that had governed the federal government for 91 years. The case is called Trump v. Slaughter. In a 6-3 decision, the court said the president can now fire the heads of independent federal agencies that were specifically designed by Congress to not answer to the president, without giving any reason at all. This isn't speculation, and it isn't a channel promising you a leaked filing. This is a real public Supreme Court opinion covered by NPR, The Washington Post, CNN, Al Jazeera, and Axios, among others. I'll link what I'm drawing from in the description. Let's actually walk through what it says, because the real version of this story is genuinely significant. You don't need to invent anything to make it matter. What actually happened? Here's the short version. In 2024, Trump fired Rebecca Kelly Slaughter, a Democratic commissioner on the Federal Trade Commission, without giving a stated reason. Slaughter sued, arguing the firing was illegal because since 1935, a Supreme Court precedent called Humphrey's Executor has said the president can only remove FTC commissioners for cause, things like neglect of duty or actual misconduct, not just political disagreement. A lower court agreed with her and ordered her reinstated. The case went up to the Supreme Court, and on June 29th, the court sided with Trump 6-3 along ideological lines. Chief Justice John Roberts wrote the majority opinion. The 3 liberal justices dissented. That's the case. Now let's talk about why it matters so much more than one commissioner's job. The 91-year-old precedent that just got gutted, Humphrey's Executor, dates back to 1935, when Franklin Roosevelt tried to fire an FTC commissioner over a policy disagreement. The Supreme Court back then ruled unanimously against Roosevelt, saying the FTC's work is quasi-judicial and quasi-legislative rather than purely executive, meaning Congress was allowed to insulate it from presidential control. That 1935 ruling became the legal foundation for a whole category of government. Independent agencies, places like the FTC, the Federal Communications Commission, the Consumer Product Safety Commission, bodies that are supposed to make decisions based on expertise and law, not on which party currently holds the White House. The court had already chipped away at this once before, in Trump's first term, when it let him fire the head of the Consumer Financial Protection Bureau, but the reasoning there was narrow. The CFPB has a single director, not a multi-member board, so the court said that specific structure didn't get Humphrey's protection. Trump v. Slaughter removes that narrow distinction. Multi-member boards are no longer safe either. As Chief Justice Roberts put it in the majority opinion, if anything was still left of the old precedent, the court was overruling it now. That's about as close to an explicit, "this case is dead," as a majority opinion gets. It's worth understanding the legal theory driving this, because it's not new. It's decades old. And this ruling is really its biggest single victory yet. It's called the unitary executive theory, the idea that the Constitution gives all executive power to one person, the president, and that Congress can't carve out little pockets of the executive branch and hand them semi-independent status. Conservative legal thinkers have been building this argument since at least the Reagan era. Attorneys who've served in the Trump administration, like James Burnham, have argued for years that there's really no such thing as a truly independent agency under the Constitution. Everything has to sit inside one of the 3 branches, and if an agency enforces federal law, it's part of the executive branch, full stop, no matter what Congress named it or how it structured the board. For decades, that was a minority view among judges. Humphrey's Executor stood specifically because the court in 1935 decided the FTC's work was different enough from the president's core powers, more like a referee than a general, that Congress could insulate it. The 2020 CFPB case was the first real crack. The court said a single all-powerful director, answerable to no one, was too much unchecked authority concentrated in one unelected official, so that structure lost its independence. But at the time, the court was careful to say multi-member boards, like the FTC, were still a different protected category. Trump v. Slaughter is the moment that distinction collapsed. The unitary executive theory, after roughly 40 years as a minority position, is now, for practical purposes, the law of the land for agency leadership. What this actually changes, practically, Here's where it stops being abstract. The FTC was designed by Congress so that no single political party could ever hold more than 3 of its 5 seats, a built-in bipartisan check. After this ruling, a president can simply fire commissioners from the opposing party whenever he wants and leave those seats empty. That's not hypothetical, it's already what happened. After Trump's firings, every remaining FTC commissioner is a Republican. And it doesn't stop at the FTC. The same legal logic now puts a question mark over the independence of several other agencies people rely on without thinking about it much. The Equal Employment Opportunity Commission, which handles workplace discrimination complaints, the Merit Systems Protection Board, which hears federal employees' disputes, the Consumer Product Safety Commission, which is the reason your kids' toys get recalled when they're dangerous. Trump has already fired Democratic members from several of these agencies, too, and this ruling makes it much harder for any of them to win reinstatement in court. So practically, the guardrail that kept antitrust enforcement, consumer safety rules, and workplace protections from swinging entirely with each election just got a lot weaker. Let's slow down on each of those 3 agencies for a second, because they're not abstract. The Merit Systems Protection Board is where federal employees go when they believe they've been fired illegally or unfairly. It's the internal check that keeps the civil service from turning into pure political patronage. Its chair, Kathy Harris, was among the officials Trump removed earlier this year. Her case was part of the broader legal fight this ruling now resolves against her position. If that board's leadership can be swapped out at will, the whole point of having a neutral body hear federal employees' disputes gets a lot shakier. The EOC is the agency that investigates workplace discrimination complaints, race, sex, disability, age discrimination on the job. It's designed to apply the same civil rights laws regardless of which party is in office, precisely because discrimination law isn't supposed to be a partisan issue. A leadership that can be entirely replaced whenever an administration changes puts that consistency at risk. And the Consumer Product Safety Commission is the reason a defective space heater or a toy with a choking hazard gets recalled before more people get hurt, rather than after. It's slow, unglamorous work that depends on continuity and expertise built up over years. Exactly the kind of function unitary executive theory says shouldn't be shielded from presidential control, and exactly the kind of function critics worry becomes less reliable once it can be. One big exception, the Federal Reserve. Here's the part of the ruling that's honestly the most legally interesting, and it's the part a fabricated version of this story would probably skip, because it complicates the Trump gets total power narrative. The same day, in a related case, the court ruled 5-4 that Federal Reserve Governor Lisa Cook could stay in her job while litigation continues, meaning the court did not extend the same reasoning to the Fed. The majority drew a specific carve-out for the Federal Reserve, treating it as different enough from agencies like the FTC to keep some insulation intact, for now. Legal critics have pointed out this is a genuinely awkward line to draw. 2 justices from the conservative majority itself, Clarence Thomas and Amy Coney Barrett, reportedly objected to the inconsistency of applying a rigid, the president controls everything rule to the FTC, while carving out a special exception for the Fed on the very same day. Georgetown law professor Steve Vladek put it memorably, saying the court seems to use history and legal text the way someone uses a lamppost, for support, not to actually see by. So this isn't a clean, total transfer of power. It's a big one, with a specific, contested exception the court hasn't fully explained yet. It's worth sitting with why the Fed carve-out exists at all, because the court's own reasoning here is thin. The majority suggested the Federal Reserve is different enough, structurally unique, tied to a distinct historical tradition, in the language some justices have used, to warrant special treatment, separate from other multi-member agencies. But critics point out that the Fed's board is a multi-member body just like the FTC's, appointed the same way, and the majority didn't offer a detailed constitutional principle for why one gets full presidential control and the other doesn't. It reads, to some critics, less like a legal distinction and more like the court recognizing that letting a president fire Federal Reserve governors at will, with direct implications for interest rates, inflation, and the entire financial system, was a step too destabilizing to take in the same ruling, even if the underlying legal logic doesn't obviously support treating it differently. That tension is exactly why Justices Thomas and Barrett, despite being part of the conservative majority that decided the FTC case, pushed back on the inconsistency of drawing the line in this particular place. If you're going to say the Constitution gives the president total control over agency leadership, doing that everywhere except the one institution most directly tied to the economy is a hard position to defend on pure legal principle, and it's a sign the Fed question isn't actually settled so much as postponed. It wasn't a clean sweep for Trump either. This matters for accuracy. And it's the kind of detail that gets left out of the fabricated versions of this genre, because it complicates the villain wins everything arc those scripts need. The same term, the court actually ruled against Trump on 3 other major issues, all written by Chief Justice Roberts himself. It blocked Trump's emergency global tariffs, it preserved Lisa Cook's position at the Fed for now, and, this is a big one, it struck down Trump's executive order attempting to end birthright citizenship for children of undocumented or temporary immigrants, in a 6-3 ruling. So the accurate picture isn't the court just handed Trump unlimited power. It's more specific and more interesting than that. This term, the court dramatically expanded the president's control over the internal machinery of the executive branch, while simultaneously blocking some of his most aggressive individual policy moves. Multiple legal commentators have described the broader pattern of the term as the court concentrating power in the presidency and in itself, often by moving disputes onto its fast-moving shadow docket, where cases skip full briefing and rulings arrive quickly with little explanation, while narrowing what Congress and lower courts can do to check either one. It's worth actually naming what else happened this term, because the pattern is more revealing than any single ruling. The court also, separately, ruled that federal courts couldn't review Trump's decision to end temporary humanitarian protections for people from Haiti and Syria, a 6-3 ruling that effectively removed judicial oversight from that particular presidential decision entirely, regardless of the reasoning behind it. In a case involving a Rastafarian inmate whose dreadlocks were forcibly cut by prison guards, the same conservative majority ruled people couldn't sue under a federal law meant to protect prisoners' religious rights. The court also gutted a major piece of the Voting Rights Act, making it far harder to challenge electoral maps that dilute Black and Latino voting power, and struck down long-standing limits on how much political parties can spend in coordination with candidates. Zoom out across all of it, and a legal historian at Boston University, Jed Sugarman, has described the court's approach as something like a line-item veto, keeping the parts of a law it likes, discarding the parts it doesn't, case by case. Steve Vladek's read is similar. He said the real headline of the term might be, "The Supreme Court rules for itself, since so many of the outcomes, regardless of which party they nominally help, expand the court's own discretion over Congress and the lower courts, at the expense of both." That's a very different and much more precise story than Trump gets a scary new power. It's closer to several long-running legal theories about executive authority and judicial review, all won decisively in the same 8-week stretch, with the court positioning itself as the final word on nearly all of them. Why this isn't just a DC story? I want to bring this down to something concrete. Because removal power over independent agencies sounds like a dry constitutional law topic until you connect it to what these agencies actually do day to day. The FTC investigates whether big tech companies, pharmaceutical companies, and other corporations are breaking antitrust or consumer protection law. The CPSC is the reason unsafe toys and appliances get pulled from shelves. The EOC is where people file complaints about workplace discrimination. These agencies were deliberately built to run on expertise and continuity across administrations, not to reset every 4 years based on who's president. The practical effect of this ruling is that all of that now depends much more heavily on which party controls the White House. An agency that was investigating a company aggressively under one administration can have its entire leadership replaced and its priorities reversed almost overnight under the next one. Legally, cleanly, without needing to show any wrongdoing by the people being removed. Whether you think that's a good thing or a bad thing genuinely depends on your view of how government should work. If you think elected presidents should control the whole executive branch, this ruling is a long overdue correction. If you think some functions, refereeing markets, protecting workers, keeping unsafe products off shelves, work better when they're insulated from short-term politics, this ruling is a real loss. Both of those are legitimate positions, and legal scholars across the spectrum are actually debating exactly that trade-off right now, not whether the ruling happened. It helps to put this in historical context, because president wants more control over agencies isn't new. What's new is a court actually agreeing at this scale. Nixon-era officials pushed similar arguments in the 1970s and lost. The Reagan administration built out the modern unitary executive theory in the Justice Department's Office of Legal Counsel through the 1980s, largely as an academic and internal executive branch position rather than something courts accepted. It resurfaced again under George W. Bush, particularly around signing statements and control over regulatory agencies. Each time, it stayed a minority legal position, until the CFPB case in 2020 cracked the door, and now Trump v. Slaughter has essentially walked through it. This is the payoff of a roughly 40-year legal project, not a sudden invention of this administration, even though this administration is the one benefiting from it. It's also worth noting who doesn't get to use this new power the same way. This ruling is specifically about a president's authority over agencies within the executive branch. It doesn't touch Congress's own staff, doesn't extend to state governments, and, as we'll get to, doesn't even fully extend to every part of the federal government, because of the Fed carve-out. So this is a real and significant expansion, but it has a defined shape. It's not the presidency can now do anything. It's specifically the presidency now has much stronger, more direct control over who runs the agencies that write and enforce federal regulations. What people are actually saying. A couple of real voices worth hearing directly, because they capture the actual disagreement well. Rebecca Slaughter herself, before the ruling came down, argued that these agencies need independence, specifically so their decisions can be based on facts and law, rather than political convenience. A case for why the old rule existed in the first place. On the other side, James Burnham, an attorney who served in both Trump administrations, has argued for years that the entire concept of an independent agency was constitutionally shaky from the start, since the Constitution places all executive power in the presidency, full stop. From that view, this ruling isn't radical. It's just the law finally catching up to what the Constitution always said. Trump himself, unsurprisingly, called the ruling a historic and unprecedented win, saying it expanded presidential power at a moment when he says it's needed. Interestingly, his public reaction to the court overall shifted across the term. He'd sharply criticized the justices earlier in the year over the tariff ruling, at one point calling the judges who blocked his emergency tariffs an embarrassment to their families. But by the end of the term, after this string of wins on executive power, his tone toward the court had cooled into something closer to praise. That shift itself is a small, real data point about how much this particular ruling mattered to him relative to the losses. Chief Justice Roberts' own language in the majority opinion is worth hearing directly because it lays out the theory in plain terms. He wrote that, while the Senate decides whether to confirm the people a president wants to work with, neither Congress nor the courts can force him to keep working with people he doesn't want, and that officials exercising presidential power are accountable to the president precisely because they can be removed by him. That's the unitary executive argument, stated as plainly as it gets in an actual opinion. Why the real version is more useful than the fake ones. Here's the honest comparison worth making, since it's the reason this whole exercise matters. A fabricated version of this story, the scary power genre, would probably invent an unnamed insider, a leaked memo, a countdown clock to some dramatic deadline, and a villain who wins everything cleanly. It would skip the Fed carve-out because internal disagreement complicates a clean narrative. It would skip the birthright citizenship loss and the tariff ruling because a president losing 3 big cases the same term doesn't fit a total power story, and it would invent quotes from named experts rather than pulling from things they've actually published or said on the record. The real version is messier. And that messiness is exactly what makes it trustworthy. Real Supreme Court terms produce mixed results, internal disagreement even within the majority, carve-outs that don't fully make sense yet, and ongoing litigation with no clean ending. If a story about a major ruling ties up too neatly, no loose ends, no contradictions, no genuine internal argument among the justices, that's worth treating as a signal rather than a coincidence. This ruling has all of that texture, and none of it had to be invented to make the video worth watching. What actually happens next? A few real, concrete things to watch, rather than invented future deadlines. Litigation over the Federal Reserve's carve-out isn't finished. Lisa Cook's underlying case is still working through the lower courts, and given how contested the Fed exception already is among the justices themselves, that's a real fight still to come. If a future case forces the court to explain in more detail why the Fed gets treated differently from the FTC, that opinion could either cement the carve-out or narrow it, and either outcome would be a much bigger deal than it might sound, because it determines whether the country's central bank remains insulated from direct presidential control over interest rates and monetary policy. Watch the other agencies too. The EOC, the Merit Systems Protection Board, the CPSC, since this ruling gives the administration a much stronger legal footing to remove members there as well, and further litigation from any of those firings would likely lean heavily on this decision. Each of those cases, if they reach the Supreme Court, will be a chance to see how far lower courts are willing to extend Slaughter's logic without the justices having to spell it out every time. It's also worth keeping an eye on the shadow docket pattern itself, separate from any individual ruling. A growing share of the biggest fights over Trump's use of executive power, immigration enforcement, frozen foreign aid, mass firings of federal workers, changes to voting maps, are being decided through this fast, low-visibility process rather than through the normal path of full briefing, oral argument, and a detailed written opinion. Shadow docket orders often arrive unsigned with little or no explanation for the reasoning behind them. That matters beyond any single case because it affects how much the public and lower courts can actually understand about why the court is ruling the way it is, which in turn makes it harder to predict or hold accountable the reasoning behind future rulings in this same area. And zoom out, legal commentators are already framing this term as a broader shift of power toward both the presidency and the court itself, at Congress's expense. That's a trend worth tracking over the next several terms, not just a one-time headline. If you want a single number to hold on to, this was one ruling in one case about one commissioner's job, but it resolved a legal argument that's been building for roughly 40 years, and it will likely shape how every future president of either party is able to control federal agencies for decades to come. That's the actual scale of the story, without needing to inflate it. So that's the real version of the Supreme Court just gave Trump a scary power. No invented judge, no fabricated quote, no page citation from a filing that doesn't exist. Just an actual 6-3 ruling that removed a 91-year-old check on presidential power over multi-member agencies, the payoff of a 40-year legal theory, a genuinely contested exception for the Fed that two of the conservative justices themselves flagged as inconsistent, and all of it happening in the same term the court also ruled against Trump 3 separate times on tariffs, birthright citizenship, and, for now, the Fed itself. That complexity is the real story, and it didn't need any embellishment to be worth your time. If you want, I can do a follow-up specifically on the Federal Reserve carve-out since that fight isn't over, or on how lower courts start applying this ruling to the EOC and CPSC cases still working their way up. See you in the next one.